Now let's talk about a really important topic, which is exceptions to full compliance with the ADAG standards. So the first issue that I want to look at is structural impracticability. Okay, and what the regulations say, and we have it highlighted here, is that full compliance with the requirements of this section is not required when an entity can demonstrate that it is structurally impracticable to meet the requirements. Full compliance will be considered structurally impracticable only in those rare circumstances when the unique characteristic of terrain prevent the incorporation of accessibility features. Okay? So, what does this mean? You can certainly imagine, or any person can certainly imagine a situation where, for example, providing a flat parking lot is impossible because of the terrain. What comes to my mind immediately is building in San Francisco, and the sidewalks obviously can't be flat, although that's Title II, that's not a Title III issue. But certainly there are areas where you're in a mountainous region and it is just impossible to make things flat the way they're supposed to be. Or, for example, if you're in an area that floods a lot, if you're in Miami and an area really has to be on an angle, it really has to have an incline for drainage purposes, otherwise there will be massive flooding. These are the types of situations that make it structurally impracticable, but they're very, very rare. And you see, it says right within the regulations, those rare circumstances, because these are very rare circumstances. And, it may turn out that this is a defense in a lawsuit, that it's structurally impracticable. And frankly, who wants to be there? Who wants to be in a position where you're in a lawsuit in the first place arguing that structural impracticability? So to the extent that something is not genuinely, completely structurally impracticable, it should be implemented. Full compliance, I'm going on now here, Section 2. Full compliance with this section would be structurally impracticable. If full compliance with this section would be structurally impracticable, compliance with this section is required to the extent that it is not structurally impracticable. In that case, any portion of the facility that can be made accessible shall be made accessible to the extent that it is not structurally impracticable. If providing accessibility in conformance with this section to individuals with certain disabilities, e.g. those who use wheelchairs, would be structurally impracticable, accessibility shall nonetheless be ensured to persons with other types of disabilities. So this is saying two things. First of all, you still got to do it to the maximum extent that it is practicable, even if you're in a situation where full compliance is structurally impracticable. And second of all, you don't get a pass on all areas of the ADA simply because some things would be structurally impracticable. But certainly structural impracticability can be an issue in some of these cases, though again, it is very rare. Okay, another issue is alterations. So if a building was built before the standards, before the 1991 standards, let's say, then it only has to comply with the ADA to the extent that doing so is readily achievable, which is something we're going to talk about in a minute. But if there's an alteration made to an area, that area now has to come into compliance with the applicable ADA standard, which today is the 2010 standards. So section 36.402 of the regulations discuss alterations. Any alteration to a place of public accommodation or a commercial facility after January 26, 1992 shall be made so as to ensure that to the maximum extent feasible, the altered portions of the facility are readily accessible to and usable by individuals with disabilities, including individuals who use wheelchairs. So, the language here is pretty clear. To the maximum extent feasible means that to the maximum extent that it's possible to do so, any alteration has got to comply with the ADA. And oftentimes in these lawsuits, you'll see an allegation that the building was either built after the date that the ADA came into compliance and therefore was required to comply fully with these regulations, or was built beforehand, but the areas at issue were altered subsequent to passage of the law, and therefore the changes have to be made not to the extent readily achievable, which is a lower standard, but to the extent to the maximum extent feasible, which is a higher standard. The law goes on to explain, what is not considered an alteration that's subject that triggers this requirement. Things like just a paint job or removing wallpaper, and it's all here. It's all very clear. It says what is and is not a modification or a renovation that will trigger this requirement. It can be read very easily. It's all free online. It's all very clear. The bottom line is, if there's a renovation or a modification to an area of a building that was built before the ADA, that may trigger the requirement to comply, and the defenses to noncompliance will be much more difficult. Okay, now we get to in my mind, the biggest topic for buildings that pre-exist the ADA, which is what is readily achievable. Remember, the law only requires that existing facilities remove barriers, comply with the ADAG to the extent that it is readily achievable to do that. So what does it mean to be readily achievable? Readily achievable means easily accomplishable and able to be carried out without much difficulty or expense. In determining whether an action is readily achievable, factors to be considered include the nature and the cost of the action needed under this part, the overall financial resources of the site or sites involved in the action, the number of persons employed at the site, the effect on expenses and resources, legitimate safety requirements that are necessary for safe operation, including crime prevention measures, or the impact of otherwise of the action upon the operation of the site, the geographic separateness and the administrative or fiscal relationship of the site or sites in question to any parent corporation or entity, if applicable, the overall financial resources of any parent corporation or entity, the overall size of the parent corporation or entity with respect to the number of its employees, the number, type, and location of its facilities, and, if applicable, the type or operation of any parent or corporation or entity, including the composition, structure, and functions of the workforce of the parent corporation or entity. Why is this important? I always think of readily achievable myself as easily accomplishable without undue burden or expense. That's a very subjective thing. And you want to keep in mind, or really any business that is thinking about whether or not to undertake barrier removal in the context of whether it's readily achievable, would be certainly be wise to keep in mind that these are very subjective standards. And they also open up a defendant in litigation in a lawsuit to tremendous discovery of their finances and of their books and records, to the extent that that business has claimed that a change is not readily achievable. Because if that's the claim, that it's not readily achievable to remove barriers, well, then that becomes an issue in the lawsuit, and the plaintiff is certainly entitled to examine whether or not the company or its parent is capable of making those changes, which can be very intrusive. Whether something is readily achievable or not really boils down to whether or not it can be afforded. And at the end of the day, if it were to go to the end, that would be a question for the court to determine on the basis of the overall financial resources, basically, of the entity. A business should remove all barriers that it can, unless it really simply is structurally impracticable or just not readily achievable. It just cannot be accomplished. But if it can be accomplished, okay, even if it takes some work and some money, but it can be accomplished, it really needs to be done, and the ADA needs to be complied with. Remember, it may feel to come to the conclusion that something is not readily achievable and just leave a barrier in place may or may not be legally correct based on the particular characteristics of the property or of the entities that of the public accommodations that are responsible for that property. But either way, it could result in a lawsuit, and that's not a place that any business wants to be in. So really, barrier removal is something that should be a top priority unless it really, really, for some reason, cannot be done and the building predates the ADA. Again, that's my opinion. It's not applicable to any particular situation. It's a general opinion. But whether or not the readily achievable standard applies in any particular case is something to really discuss with your own legal counsel if it's something that is being considered. Okay, so what if it is not readily achievable, genuinely not readily achievable, to remove barriers in an existing facility, a facility that predates the ADA? That does not mean that the facility is able to just say, well, I guess, we're going to wash our hands of accessibility. And the regulations really address this head on, stating that where barrier removal would not be readily achievable, a public accommodation may take other readily achievable measures to remove the barrier that do not fully comply with the specified requirements. Such measures include, for example, providing a ramp with a steeper slope, or widening a doorway to a narrower width than that mandated by the alterations requirements. No measure shall be taken, however, that poses a significant risk to the health safety of individuals with disabilities. Now, portable ramp. This is a big one. This is one that I see often as a solution where putting in a ramp is just impossible for various reasons. And the regulations for that reason address it specifically. Portable ramps should be used to comply with this section only when installation of a permanent ramp is not readily achievable. In order to avoid any significant risk to the health or safety of individuals with disabilities or others in using portable ramps, due consideration shall be given to safety features such as non-slip surfaces, railings, anchoring, strength of materials. Okay, so there are oftentimes cases where a ramp just cannot be installed, either because of the physical properties of the building, maybe the front entrance has a step and it's right on the road or right on the sidewalk. And in those cases, it may be that the only alternative is a portable ramp. Oftentimes, a portable ramp will be will come along with, at least part of a settlement agreement in a lawsuit, signage bearing the international symbol of accessibility, which is the wheelchair symbol, and either a buzzer or a phone number to call, and training of staff that when they hear that buzzer, when they get a call on that number, how to go out and deploy the portable ramp. There are a lot of portable ramp options. Look it up online. There are a lot of options that have, some of them get pretty sophisticated. But again, it's only a solution where it is really not readily achievable to have a ramp. And I myself have represented multiple businesses that have a portable ramp available and have still gotten sued for not having a regular ramp. So from the perspective of creating accessibility, where a ramp is really not readily achievable, the regs do say that a portable ramp can be used, but again, it may not be the best risk mitigation strategy to use a portable ramp. So now I'm going down to the next section, F, selling or serving spaces. The rearrangement of temporary or movable structures, such as furniture, equipment, and display racks, is not readily achievable to the extent that it results in significant loss of selling or serving space. So that obviously is very important for stores in particular. Okay. I pulled out this this section here, section 103, equivalent facilitation, because I think it's important. The responsibility for demonstrating equivalent facilitation in the event of a challenge rests with the covered entity. With the exception of transit facilities, which are covered by regulations issued by the Department of Transportation, there is no process for certifying that an alternative design provides equivalent facilitation. So I have seen cases where equivalent facilitation is provided. So, for example, if there's a countertop and it's too high, instead of rebuilding the counter, or let's take a specific example that I have in mind, a bar that's 100 years old, and it has a bar that is about as old as the bar itself, like a bar where people sit, and it's an antique. It's been there for almost a century. It's a beautiful piece of furniture, but it's not ADA compliant. Oftentimes, equivalent facilitation will be provided, which means a lower table, a table that does meet ADA requirements, that is in the exact same area and where the same services are provided. But equivalent facilitation is something that, again, as the regulations say, it's the responsibility of the covered entity of the business to prove that it provides equivalent facilitation and that it's really necessary. So where something is not readily achievable, it may be possible to provide equivalent facilitation. It's certainly something that happens quite often, but the burden will be on the covered entity to demonstrate that that is providing the required level of accessibility, and that providing real accessibility was not readily achievable, of course. Okay. Now, alternatives to barrier removal. So again, we're continuing here now with the theme of things not being readily achievable, not to remove, barriers that cannot be removed in a readily achievable way. And this is section 36.305, alternatives to barrier removal. So where a public accommodation can demonstrate that barrier removal is not readily achievable, the public accommodation shall not fail to make all of its goods, services, facilities, privileges, advantages, or accommodations available through alternative methods if those methods are readily achievable. And this relates back to what we were just talking about, equivalent facilitation. So even if something is not readily achievable, it still falls on the business to provide some type of an equivalent in order to create access to the same goods and services for the disabled. You can't just say, well, it's not readily achievable and wash your hands of it. A business can't just abdicate all responsibility because something is not readily achievable. It still has to come up with solutions in order to create access for the disabled. So, examples of alternatives to barrier removal include, but are not limited to, the following: providing curb service or home delivery, retrieving merchandise from inaccessible shelves or racks, relocating activities to accessible locations. So these are specific examples given. Another example is the one I just gave with the bar. But the bottom line is you have to remove barriers to the extent readily achievable. And if it's just not readily achievable, access still has to be created, but you got to find some equivalent way to do it, whether it's a portable ramp, whether it's providing services in another area that are accessible, providing curb service, whatever the case may be. A business really should do a survey, make sure it has no barriers, and to the extent that it has barriers that cannot be removed, think through equivalent ways to provide access to the disabled in those cases. Now, the ADA does not, however, require personal devices and services. So this part does not require public accommodation to provide its customers, clients, or participants with personal devices, such as wheelchairs, individually prescribed devices such as prescription eyeglasses or hearing aids, or services of a personal nature. So while the ADA does require a lot, and it requires even a lot more than we've discussed so far, it does not require that personal devices. If somebody comes and they can't walk, it is not an ADA violation to not have, for example, a wheelchair on hand for them to use. Okay, next slide. There is an elevator exemption, which is important to know about if you have an elevator. Section 36404 of the regs, which says this section does not require the installation of an elevator in an altered facility that is less than 3 stories or has less than 3,000 square feet per story, except with respect to any facility that houses a shopping center, a shopping mall, professional offices of a healthcare provider, a terminal, depot, or other station used for specific public transportation, or an airport passenger terminal. Again, if a business has a facility and the facility has an elevator in it, it's important to consult with counsel about whether or not the altered facility has to install an elevator or not as a result of the alteration. And now we get to a topic which is, in my experience at least, something that comes up not infrequently, which is being a historic property, a historic building. I in particular have represented a lot of businesses in New York City, where there's obviously a lot of very old buildings, and the question comes up whether or not being a historic building or past a certain age means that you are somehow grandfathered into the law. And let me actually take this opportunity to discuss this concept of grandfathering. I speak to a lot of people who tell me that they're grandfathered in because they predate the ADA. Hopefully, if I've done my job here, everyone now understands that buildings that predate the ADA must comply with the regulations, with the ADAG, remove barriers, to the extent readily achievable. That is the only difference between buildings that predate the ADA, that are untouched since before the ADA came into existence, and later construction, is that the older buildings have to comply to the extent readily achievable. There is no grandfathering in. This law applies to everyone. The only difference is that to some buildings it applies absolutely, to other buildings it applies to the extent readily achievable. And of course there are these other different factors and standards that we've discussed. For example, maximum extent feasible for pre-ADA buildings that are renovated post-ADA, structural impracticability where it's virtually impossible to comply. But just generally speaking, broad strokes here, pre-ADA, there is no grandfathering in. It's just that barrier removal is only necessary to the extent readily achievable. But let's talk about historic buildings. So in this section, 36.405 says alterations, historic preservation. Alterations to buildings or facilities that are eligible for listing in the National Register of Historic Places under the National Historic Preservation Act are designated as historic under state or local law shall comply to the maximum extent feasible with this part if it is determined, so shall comply to the maximum extent feasible. If it is determined that it is not feasible to provide physical access to a historic property that is a place of public accommodation in a manner that will not threaten or destroy the historic significance of the building or facility, alternative methods of access shall be provided pursuant to the requirements of Section C of this part. The bottom line is that there is a bit of a different standard applying to actual registered historic places to the extent that it's not feasible to make changes without affecting the historic the historic significance of the building. But again, any business that is housed in or that's running a historic building registered either on the federal, state, or local level as a historic building should consult with their counsel to determine what exactly they do and don't have to do to comply with the ADA. But it is untrue to say that they can simply ignore it because they're a historic building.